So I said today I'm just going to move on as though we actually had that class in those videos, but those videos are 100% online, and I do spend a lot of time in Craig v. Bourne talking about intermediate scrutiny. So it's there. All right, barring no other questions, moving on. All right, Michael M. versus Sonoma County Superior Court gives us sort of a different look at gender-based discrimination. This case happens under Justice Rehnquist, who's about to become Chief Justice Rehnquist soon, and it's a 5-4 decision. So this is a much more sharply divided court. So at the time, California's statutory rape law provided that males were criminally responsible for sexual intercourse with females under the age of 18, but not the other way around. And if convicted for statutory rape, it was considered a felony. So to put this sort of in as an example, the age of consent for women in California is 18, but there's no comparable age of consent for men. So in this particular case, a 17-year-old male was convicted under the statutory rape law for having sex with a 16-year-old girl. Statutory rape is a crime in which the nature of force is entirely irrelevant. So even if the sex was considered consensual, the law provides that because of the woman's age, she is legally incapable of consenting to sexual activity. There existed at the time of the case conflicting evidence about whether or not there was forcible sexual activity involved in this case. The evidence cut sort of both ways. But the prosecutors ultimately decided not to bother with the forcible rape charge because the statutory rape charge, which was also a felony, was available, and they didn't have to demonstrate that force was involved because statutory rape laws simply read that any woman in the state of California under the age of 18 was incapable of consenting to sexual activity. Well, the male in this case claims that this statute unconstitutionally discriminated against him. The California Supreme Court works kind of oddly, and they ruled that strict scrutiny in this case was necessary. So not the intermediate scrutiny standard that the Supreme Court has put forth, but that strict scrutiny standard is applicable. But even under that strict scrutiny standard, that really high bar to meet, the statute served a compelling state interest, and that compelling state interest was to avoid the cost of teenage pregnancies. So the Supreme Court has to consider whether the law in this case, the statutory rape law, is a violation of the 14th Amendment Equal Protection Clause based on gender-based discrimination. So we have another case that's looking at gender-based discrimination from the point of it actually hurting men as opposed to hurting women. The Supreme Court validates the decision of the California Supreme Court and holds that this law does not violate notions of equal protection because the law served a state interest, and that interest was to avoid the cost of teenage pregnancies. They argue that California is ultimately justified in trying to decrease teen pregnancies, and by holding males criminally responsible under the law is sufficiently related to the state's objectives. Note that that language is important, sufficiently related to the state's objectives. This is not the intermediate scrutiny standard. The intermediate scrutiny standard is substantially related to the state's objectives. Sufficiently related to the state's objectives is much closer to the rational basis standard. If you look back at Craig v. Bourne, you'll note that Rehnquist was completely against the idea of a heightened level of scrutiny for gender-based cases. So when he writes this case, he actually reduces the level of intermediate scrutiny. He still voices and gives lip service to the idea that he is using intermediate scrutiny standard, but in actuality, he's using something more close to rational basis than the intermediate scrutiny standard that is established in Craig v. Bourne. And we'll see throughout this section that depending on who is writing the opinion, the intermediate scrutiny test sort of swings back and forth. And in this case, with Justice Rehnquist writing, it swings much closer to the rational basis test. It's important to note, however, that even though Rehnquist writes what we would consider the majority opinion, it's only a plurality. And it's only a plurality because he only got 4 justices to agree with him in terms of the opinion. Justice Blackmun is ultimately the 5th vote in the outcome of the case, and he argues that the standard should be intermediate scrutiny, but even under that standard, this law would remain constitutional. 3 justices dissent together, and Justices Brennan, Marshall, and White, and they argue that the majority of the court places so much emphasis on the first part of the test for intermediate scrutiny that the government has noting that the government has an important interest in decreasing teen pregnancies. It absolutely provides no balance on the second part of that test, which is whether the law in question is substantially related to that goal. And these 3 justices argue that the law is not substantially related to the goal. The goal for them, the goal for California, was to reduce the number of teenage pregnancies. And the dissenters these 3 dissenters point this out, that actually takes 2 parties. Teenage pregnancy, in fact, every pregnancy, takes 2 parties. And this law only criminalizes one of those parties. And so if the goal is to decrease teenage pregnancy, and you're going to do that through felony-based criminal action, well, then you actually have to criminalize both parties who were involved in the action. Justice Stevens perhaps has the most cutting dissent for this case. And he argues that if your goal is to promote a reduction in teenage pregnancies, but your statute only prosecutes half of the guilty parties, then it's a violation of just the notion of good law. It's irrational, he argues, to exempt 50% of potential violators of the law. His argument is that strict scrutiny standards should apply because his reasoning stems from notions of liberty, as no person should be denied life, liberty, or property without due process, without equal protection. Well, his argument is that since the male defendant in this case can lose liberty based on this law, felony convictions being notable of having jail time, that's a fundamental interest. And anytime a fundamental interest is involved, strict scrutiny standards have to apply. He also doubts the majority's arguments that statutory rape laws would cut down on teenage sex, which should be notable considering statutory rape laws are ubiquitous across the United States. And it really hasn't cut down on teenage sex. He argues that custom, belief, rather than law, have a greater impact on teenage behavior. Furthermore, because Stevens goes on, this is probably one of his most impassioned dissents, he argues that because this is primarily a gender issue, because if teenage girls are truly at risk of pregnancy and STDs, then exempting females from prosecution is absolutely absurd. You have to understand, Justice Stevens was nominated by a Republican. He was considered to be a conservative justice, but as early as 1981 in this case, we see that there has become a significant, what we would consider ideological divide on the court, and Stevens has chose to side significantly with the liberals in this case. The law at question in this case was changed in 1991. So California changed its statutory laws by prohibiting and criminalizing sex by anyone, male or female, under the age of 18, unless the offenders are within 3 years of age of each other. That's a similar law that now exists in most jurisdictions. But the law as previously written was common at the time. So in this case, while the intermediate scrutiny standard is used by the majority, it's much closer to what we would consider a rational basis test than the actual intermediate scrutiny test that's articulated in Craig v. Bourne.